Hello everyone. Welcome to our video. The topic that we are going to present today is Chapter 5, State Sovereignty and Jurisdiction. This video is brought to you by The outlines of this video are: have you ever wondered, what is sovereignty and how can a country be considered as a sovereign state? Well, in international law, sovereignty is the exclusive right of a state to govern the affairs of its inhabitants, and to be free from external control. In simple words, it means one state are strictly prohibited from intruding into the internal affairs of another. According to Article 1 of Montevideo Convention in 1933, a sovereign state must fulfill 4 criteria, which includes: first, a permanent population. Second, a defined territory. Third, a government. And fourth, the capacity to enter into relations with other states. Hence, these are the examples of recognized sovereign states. But what about entities such as Taiwan and Kosovo? Can we consider them as sovereign states as well? A state actor cannot recognize them because they are considered as quasi-states. Moving on to the next part, we are going to talk about 5 types of acquisition of sovereignty, which includes cession, occupation, prescription, accretion, and the last type will be conquest. First, cession refers to the transfer of territory by treaty from one state to another. For instance, the cession of Hong Kong and Kowloon by China to UK, and also the cession Treaty of Labuan in 1848. Second, occupation refers to a state gained sovereignty over an unclaimed territory with no possession of other sovereign power. It usually refers to terra nullius. For instance, Singapore claimed sovereignty over Pedra Blanca through this method. Third, prescription refers to a mode of establishing title to territory which is subject to the sovereignty of another state through peaceful exercise of de facto sovereignty over a long period of time. Note that the territory stated is not a terra nullius. For example, in the island of Palmas case, the judge found that the absence of Spanish protest against Dutch acts on the island. Fourth, accretion is a geographical process by which new land is formed mainly through natural causes and becomes attached to existing land. Hence, the acquisition and title to this territory need no formal act or assertion on part of the acquiring state. And the fifth, conquest is an act of defeating an opponent state and occupying all or part of its territory. It is now considered as a violation to international law. One of the modern examples of conquest is Israel's illegal conquest of Golan Heights and East Jerusalem.
So, what nationality is Inton's baby who born at 35,000 feet in the sky? And based on what principle if Inton wanted her son become a Malaysian? Nationality is the legal status, which represents the country from which an individual belongs. An individual's nationality denotes the country where he or she is born and are the legal citizen. The status is acquired by birth, inheritance or naturalization. On the basis of constitutional provisions, every state sets the criteria which determine who can be the nationals of the country. Besides that, a person cannot be a national of more than one country. In this case, Inton's baby who born in the aircraft that registered in Malaysia, which is Malaysia Airline. Even though the plane has passed by the international airspace and international sea, the baby have the right to be a Malaysian by the legal authority of Malaysian government. What is the universality in term of international law? The principle of the universality is an assumption in the public international law that allow a country, in certain situation, to pursue a criminal cause against a person who is in the country, no matter where the crime was committed or where the person lives permanently. So, which country sold penalize Martin? Actually, Both of the country France and country C can penalize Martin in the case of piracy. Therefore, the government of France have to allow the president of the country C's law, where Martin has committed crime in South China Sea area. Protective principle. A state can punish acts prejudicial to its security, integrity, or national interest, irrespective of where those acts take place or by whom they are committed. This is Iqbal.
Hello.
Iqbal, Enton's second husband, smuggled a group of children to country C. Malaysia court could take jurisdiction on him, because he is Malaysian. Passive personality principle. State can punish foreigners for crime committed abroad affecting its nationals, which focus on victims. Example: the child of President Donald Duck was one of the victims among the children who smuggling by Iqbal to country C. Therefore, based on this principle, President Donald Duck could reserve the jurisdiction right on Iqbal. Extradition. State depends on the cooperation of the other state in order to obtain surrender of suspected criminals or convicted criminals who are or have fled abroad. Example: Malaysia requests to extradite Iqbal from country C in order to take further jurisdiction action.
He is Hamdan, son of Intan. Hamdan is the captain of Diamond Prince registered under state of Malaysia. One day, the cruise ship collides with a French ship at Siam Gulf, causing the deaths of 2 Frenchmen. French arrest Hamdan and his crew. Hamdan and his crew have been locked down for 50 days. Based on this incident, French has territorial jurisdiction over cross-border offenses. What is prescribe and enforce? State jurisdiction is the capacity of a state under international law to prescribe and enforce the rules of law. It is derived from the state sovereignty and constitutes its vital and central feature. It is the authority of a state over persons, property and events which are primarily within its territories, its lands, its national airspace, and its internal and territorial water. This authority involves the powers to prescribe the rules of law, to enforce the prescribed rules of law and to adjudicate. The powers related to state jurisdiction raise the question regarding the types and forms of state jurisdiction. Conclusion. Sovereignty. It is considered a fundamental element of the existence of the state or the legitimate sources of the authority within a state. The sovereign equality of states remains the binder that coordinates the other rules and principles of contemporary international law, and it directs and organizes peace structures as a whole, in the sense of maintaining and developing peaceful relations in the world. The concept of sovereignty has developed with states and evolution of international relations, and it had to adapt to frequent challenges arising from different levels: subnational, transnational, supranational, and global. Conclusion. Jurisdiction. However, the individual state plays a leading role in a worldwide organization in spite of having multilateral agreements and centralized agreements. There must be friendly relations between the states to avoid conflicts on the territorial borders. Territorial jurisdiction and state jurisdiction plays an important role, as it is very important to follow all the rules stipulated in different provisions.